Thank you for joining us tonight. We are currently playing our pre-event slideshow. Gold text on a white background, live from NYPL logo. Live from NYPL presents We the Women, Julie Sook with Kirsten Swinth. September 15th, 2020 at 8 p.m. Eastern Time. Black text on a white background. This slide features the book jacket of We the Women. The title, We the Women, appears in black and pink print with the words We the stylized in calligraphy lettering. The subtitle and author name, The Unstoppable Mothers of the Equal Rights Amendment, and Julie C. Sook, are set in pink overlays over a zoomed-in image of the US Constitution. We the Women is available for purchase online from the library shop, nypl.org/shop. All proceeds benefit the New York Public Library. Plus, receive a free commemorative 125th anniversary tote bag with your purchase. Black text on a white background. This slide also features the book jacket of We the Women with the Simply E logo. Reserve a copy of We the Women for free with a New York Public Library card, available through Simply E on iOS and Android. Black text on a white background. This slide features the book jacket of We the Women. This title and more are available in accessible formats for community members who do not use standard print. Find out more at nypl.org/talkingbooks. Black text on a white background. Recommended reading. The New York Public Library's Essential Reads on Feminism. This list includes firsthand accounts and histories of the suffrage movement that chronicle both its successes and its limitations, particularly for women of color, as well as contemporary essays on how feminism intersects with race, class, education, and LGBTQ+ activism. It provides a starting point for learning about the history of feminism and for exploring the issues and challenges that many women face today. Find this list and more at nypl.org/feminism. Many of these titles are also available in accessible formats for community members who do not use standard print. Learn more at nypl.org/talkingbooks. Thank you for joining us tonight. We are currently playing our pre-event slideshow. Gold text on a white background, live from NYPL logo. Live from NYPL presents We the Women, Julie Sook with Kirsten Swinth. September 15th, 2020 at 8 p.m. Eastern Time. Black text on a white background. This slide features the book jacket of We the Women. The title, We the Women, appears in black and pink print with the words We the stylized in calligraphy lettering. The subtitle and author name, The Unstoppable Mothers of the Equal Rights Amendment, and Julie C. Sook, are set in pink overlays over a zoomed-in image of the US Constitution. We the Women is available for purchase online from the library shop, nypl.org/shop. All proceeds benefit the New York Public Library. Plus, receive a free commemorative 125th anniversary tote bag with your purchase. Black text on a white background. This slide also features the book jacket of We the Women with the Simply E logo. Reserve a copy of We the Women for free with a New York Public Library card, available through Simply E on iOS and Android. Black text on a white background. This slide features the book jacket of We the Women. This title and more are available in accessible formats for community members who do not use standard print. Find out more at nypl.org/talkingbooks. Black text on a white background. Recommended reading. The New York Public Library's Essential Reads on Feminism. This list includes firsthand accounts and histories of the suffrage movement that chronicle both its successes and its limitations, particularly for women of color, as well as contemporary essays on how feminism intersects with race, class, education, and LGBTQ+ activism. It provides a starting point for learning about the history of feminism and for exploring the issues and challenges that many women face today. Find this list and more at nypl.org/feminism. Many of these titles are also available in accessible formats for community members who do not use standard print. Learn more at nypl.org/talkingbooks. Thank you for joining us tonight. We are currently playing our pre-event slideshow. Gold text on a white background, live from NYPL logo. Live from NYPL presents We the Women, Julie Sook with Kirsten Swinth. September 15th, 2020 at 8 p.m. Eastern Time. Black text on a white background. This slide features the book jacket of We the Women. The title, We the Women, appears in black and pink print with the words We the stylized in calligraphy lettering. The subtitle and author name, The Unstoppable Mothers of the Equal Rights Amendment, and Julie C. Sook, are set in pink overlays over a zoomed-in image of the US Constitution. We the Women is available for purchase online from the library shop, nypl.org/shop. All proceeds benefit the New York Public Library. Plus, receive a free commemorative 125th anniversary tote bag with your purchase. Black text on a white background. This slide also features the book jacket of We the Women with the Simply E logo. Reserve a copy of We the Women for free with a New York Public Library card, available through Simply E on iOS and Android. Black text on a white background. This slide features the book jacket of We the Women. This title and more are available in accessible formats for community members who do not use standard print. Find out more at nypl.org/talkingbooks. Black text on a white background. Recommended reading. The New York Public Library's Essential Reads on Feminism. This list includes firsthand accounts and histories of the suffrage movement that chronicle both its successes and its limitations, particularly for women of color, as well as contemporary essays on how feminism intersects with race, class, education, and LGBTQ+ activism. It provides a starting point for learning about the history of feminism and for exploring the issues and challenges that many women face today. Find this list and more at nypl.org/feminism. Many of these titles are also available in accessible formats for community members who do not use standard print. Learn more at nypl.org/talkingbooks.
Well, hi everyone, and welcome to Live from NYPL. My name is Faye Rosenfeld, and I am the Vice President of Public Programs at the New York Public Library. Tonight, we are delighted to present a conversation between Julie Sook and Kirsten Swinth. They will be speaking about Julie's just published book, We the Women, The Unstoppable Mothers of the Equal Rights Amendment. If you have not already bought the book, it's available for purchase online through the library's shop, which you can find at nypl.org/shop. All purchases made there benefit the New York Public Library. Our guests this evening are both distinguished scholars and frequent commentators in the media on issues related to gender equality. Julie Sook is a legal expert who is the Dean of Master's Programs and Professor of Sociology, Political Science, and Liberal Studies at the CUNY Graduate Center. She's also a visiting professor at Yale Law School. Kirsten Swinth is Professor of History and American Studies at Fordham University. Her most recent book is Feminism's Forgotten Fight, The Unfinished Struggle for Work and Family, published by Harvard University Press in 2018. One of the many reasons we are thrilled to be hosting this program tonight is because Julie did much of her research for We the Women at the New York Public Library. But of course, it's also because we recognize that the subject matter is so important and so timely. Even as we wrap up celebrations marking the recent 100th anniversary of the 19th Amendment, granting women the right to vote, and as we head into an election cycle where over 53% of eligible voters are women, we know that fundamental questions of women's equality in our society remain unresolved. Whether that equality will or should be enshrined in the Constitution is something we should all know about, care about, and understand more deeply, and our speakers will help us do just that. For those of you who want to delve further into these subjects after tonight's conversation, and of course, after reading Julie and Kirsten's books, our expert NYPL librarians have put together a list of essential reads on feminism, which you can find at nypl.org/feminism. There are companion reading lists for kids and teens too, and also a special story time for young children hosted by another Kirsten, Senator Kirsten Gillibrand. Before I bring our speakers onto screen, I'd like to just go over a few very, very quick housekeeping notes. First, I want to let you all know this program is being recorded. That is to say, you're not being recorded, just the speakers, excuse me. Second, Julie and Kirsten will speak for around 45 minutes, and then they'll take questions at the end. You can send questions for the speakers at any time during the conversation by typing your question into the Q&A box at the bottom of the Zoom app, or in the YouTube chat, or by emailing publicprograms@nypl.org. We'll make sure they get the questions and they will answer as many as they can at the end. Finally, real-time captions are available for tonight's program via stream text. You can find the link in the reminder email as well as in the Zoom and YouTube chats. Now, please welcome Julie Suk and Kirsten Swinth.
Hi, good evening, everybody. I'm so happy to be here and to be participating in this conversation. Thank you, Faye, for that wonderful introduction. And I'm thrilled to be sitting with my friend Julie to have this conversation. As Faye mentioned, Julie, we just celebrated the 100th anniversary of the 19th Amendment, which was the last amendment or the only amendment to address issues of equality for women, granted women the right to vote. But one of the interesting things about the Equal Rights Amendment was that it was first proposed in the same years as the 19th Amendment. Why did the ERA's framers think we also needed an amendment to guarantee women's equality? And what did they believe the amendment would accomplish?
Well, thank you so much. It's such a pleasure to be here with you, Kirsten. And thank you so much to Faye and the New York Public Library for hosting this event and for a book that really would not exist without the New York Public Library's research collections. So with that in mind, the Equal Rights Amendment really comes on the scene on the heels of the Women's Suffrage Amendment. And it was because the movement for suffrage, really from the beginning, way back in the 19th century, was concerned with many agendas, including, but not limited, to the right to vote for women. And so if we just take one marker, although certainly the movement was going on before 1848, when you get the Declaration of Sentiments at Seneca Falls, the right to vote for women was tied up with an agenda of getting rid of many other sources of women's inequality under the law, specifically that women were not treated as full persons under the law or as equal citizens by any means. And this was not only constitutional law, but the existing legal orders in many states that denied women property rights, that denied married women property rights, and laws under which mothers really didn't have equal guardianship, equal rights over their own children. And so for a lot of reasons, the law operated in ways that made it impossible for women to be economically independent of their husbands. And in their dependent status, the whole notion that women couldn't vote was also tied to this idea that they didn't need to vote because they were dependent on men and men could always represent them in politics. And so when the 19th Amendment was finally ratified in 1920, some, but not all suffragists, particularly the National Woman's Party led by Alice Paul and Crystal Eastman, they argued that this was actually not the end of the long fight, but actually a beginning of a new, hopefully not so long fight, although indeed the new fight that they introduced in the early 1920s has lasted just as long.
So they really thought that the 19th Amendment was kind of utterly insufficient to really achieve the larger goals of the women's movement in this period. They had it sounds like a much more expansive vision of what constituted women's equality. And they thought the ERA would guarantee that. Was that what was going on as they were framing it and writing up the first words of the Equal Rights Amendment?
Yeah, absolutely. Well, I think that the suffragists actually split on the issue of whether the Equal Rights Amendment was the way to go. I think many of them wanted changes in law beyond simply changing who was eligible to vote. But one strategy that some of the former suffragists advocated was just using the right to vote to get legislators elected who would then pass laws that would make equality real for women. And so that was one strategy. But another strategy was to have a constitutional amendment, which in one fell swoop, a blanket amendment, as they called it, would get rid of every single state or federal law that discriminated on the basis of sex. And so there are two different strategies. And so not all of the suffragists and not everybody who identified as a proponent of women's rights put their weight behind the Equal Rights Amendment when it was first introduced in 1923.
That's super interesting, Julie. And I want to circle back around to that as we talk about the kind of more contemporary debate about why we may or may not still need an actual equal rights amendment.
Yeah.
But just to spend a little more time on this earlier period, because the 100th anniversary of the ratification of the 19th Amendment has been in the news a lot, we've heard a lot about the very complex dynamics that unfolded among the broad mass suffrage movement, including kind of extensive discriminatory and racist treatment towards many Black suffragettes. But there were also significant Black supporters of the Equal Rights Amendment. And one of the early supporters was Mary Church Terrell. She was an African-American co-founder of the NAACP. She was a founder of the Black Women's Advocacy Group, the National Association of Colored Women. Can you tell us a little bit more about Terrell and her role in advancing the ERA? I'm particularly curious about how she dealt with the racism of many suffrage supporters and ERA leaders.
Well, she's a really super interesting figure because she's actually born before the 13th Amendment emancipates enslaved persons in America. And so she's an African-American woman who goes on to actually be extremely global in focus. And she got involved with the suffrage movement and in fact worked with some of the women who are now, I think, being criticized as having made too many compromises with racists and with racism, like Susan B. Anthony and Carrie Chapman Catt, and ultimately also Alice Paul. So she worked with them at the turn of the century. She founded the National Association of Colored Women, which was interested in a lot of issues, including ending lynching in the South and segregation. But another issue that the National Association of Colored Women was very focused on was motherhood and supporting working mothers, because a lot of African-American women, even early on, worked because they had to work. So the idea that something had to be done to enable women to work with regard to childcare arrangements. And that was something that the National Association of Colored Women was very interested in. And she actually goes and talks about their work in establishing day nurseries and childcare when she speaks at an International Women's Conference in 1904 in Berlin. She travels there. Many white suffragists are also there, but they have her speak specifically about the status of African-American women in the United States and their role in the suffrage movement. And I think that her travels, that is to Berlin in 1904, but even before that, she was already fluent in German. In fact, she gave that address in Berlin in German. She was fluent in German and French, and she was very involved with international women's peace movements all the way up through the time that the suffrage amendment is ratified and later on. So her voice, you don't really see her voice in the hearings on the ERA until a little bit later. The 1940s in the post-World War II moment. And I think the post-World War II moment is actually a very important time when the tide starts turning in favor of the ERA, because in the beginning, only a few women's groups, the National Women's Party, were for it. But Mary Church Terrell actually shows up to ERA hearings in 1945 and 1948, representing the National Association of Colored Women. And she specifically talks about how the experience of African-American women, and specifically the need for mothers to work and the burdens that are sustained by women when they're mothering and working at the same time. And I think these are issues that I think the United States has been late to recognize, as you so beautifully write about in your history of the work family conflict, Kirsten. But I think for Mary Church Terrell, she was well versed in these issues because the idea that the constitutional right to equality for women was somehow connected to the state's protection for motherhood and the state's support for motherhood was a constitutional principle in many other, particularly European countries, including the Weimar Constitution in 1919 and many of the constitutions that emerged in the post-World War II period.
So she had this extraordinary cosmopolitanism, it sounds like, where she really was able to leverage her experience abroad of this wide-ranging international women's network to advance certain sets of arguments about why US women needed an equal rights amendment.
Absolutely. So what's really stunning is that her two sets of experiences, both that sharpen the attention to working motherhood as a problem, the experience of African-American women on the one hand, and internationalism on the other hand, engagement with constitutionalism outside the United States and the UN Charter, that really focuses her attention. And you see that in her ERA testimonies in the 1940s, where she talks about African-American women. She also talks about the Japanese constitution that's emerging after World War II, how it actually has a provision on equal rights between women and men. And she points out that the new constitution that Japan is getting gives women rights and protections that American women do not enjoy. And I think that is a really important moment and an important point in the 1940s, because the tide starts to turn with greater awareness of the United States participating in a larger world of human rights and gender equality being a fundamental feature of the regime of human rights that's emerging after World War II, and that being enshrined in constitutions almost everywhere, in constitutions written in the 20th century and also the 21st century.
So you talk about this period after World War II as the tide's turning and a kind of new momentum slowly starting to build for the Equal Rights Amendment. And I think it's a critical period of transition. We're meeting today, this event this evening is in part in honor of kind of Constitution Day. And one of the themes we wanted to explore was women as constitution makers. So when the 19th Amendment was sent for ratification, no female legislators were in Congress. But by the post-war period, that was not the case at all. And when the ERA was finally passed by Congress, female legislators played a significant role. So I'm wondering about the importance of these post-war mothers of the ERA, as you call them, like Patsy Mink, Shirley Chisholm, and Martha Griffiths. You tell wonderful stories of these women's roles in Congress. So I actually kind of am curious, like, who's your favorite ERA mother from this period? And how do you see her making a contribution to constitution making?
So I'm always a little bit, wary of choosing favorites because I present a whole army of amazing women in the book, but I would like to just take this moment to recognize someone who I think is often forgotten, even in stories about the ERA, and that's Patsy Mink. She was a Japanese American woman who grew up in Hawaii, and she was the first woman of color elected to Congress in 1964. And she actually lived through Japanese internment in Hawaii. It affected her, members of her community. She went to college at the University of Nebraska. And when she got there, she was put in a dorm for non-white. They segregated their dormitories. They had white students in one dorm and a separate dorm for international and non-white students. And she actually stood up and protested it. And by the time she graduated as an undergrad, they changed that policy. And so she goes on also to become one of the very few women who go to the University of Chicago Law School in graduating in 1951. And she faces a lot of discrimination as a non-white woman and a mother in trying to find a legal job. And so she ends up eventually doing a lot of family law work, helping a lot of women, and really kind of learning how to talk to members of the community, and eventually gets elected to the Hawaii legislature and then runs for a seat in Congress in the mid-1960s. And she's really, I mean, it's not just this biography that strikes me as really important to her desire to fight for women's rights and to fight for vulnerable people, of not just women, but she also has a vision of the ERA, which I think really marks it as a different kind of amendment, a real 20th century, 21st century right that's different from the rights that you see in the original Bill of Rights that written in the 18th century. And that's to say that when she was proposing the Equal Rights Amendment, she didn't see it as something that courts would use to strike down laws. And indeed, that was the original vision of Alice Paul, right? You're going to have this constitutional amendment, you use it to strike down laws at the state level that discriminate against women, and that's how it works. She actually had a vision. She said, you know what, the Supreme Court has never actually struck down a sex discriminatory law. So we want the ERA to wake up the public servants so that they understand that sex discrimination is a problem. But because of the performance of courts up until this date, she didn't want an amendment that was going to just be an instruction to judiciaries to strike down laws. She saw it, and she wasn't the only one. Women like Martha Griffiths and Shirley Chisholm very much shared her vision. But the vision was really of an amendment that would catalyze and legitimize more intense legislative activity to make equality real for women. So legislators would be in the driver's seat, not judges. Women in Congress, women in state legislatures, and their allies would then be adopting robust laws on things like equal pay and equal educational opportunity. And indeed, one of her signature issues during this time was Title IX, the statute that guarantees equal educational opportunity in federally funded educational programs. That statute was later renamed the Patsy Mink statute, largely because of her role in pushing it forward. She and Shirley Chisholm were also very active in trying to get childcare legislation passed during this time. So the Comprehensive Child Development Act, they were holding hearings. She presided over some of them. Shirley Chisholm testified at many of them. And the goal was to create federally funded childcare on demand, available to all children regardless of ability to pay, which would have made a huge difference to working mothers. And so a lot of her vision was about having the policy infrastructure, not just a constitutional right that courts would enforce, to make equality real.
So it sounds like she envisioned the Equal Rights Amendment as kind of validating this kind of broader legislative agenda that would be carried forward in Congress at the national level, but by states and localities as well. Am I understanding you right? Is that the kind of?
Yeah, absolutely. And of course, that's baked into the text of the amendment as well, because in addition to the words that we typically focus on, guaranteeing equality of rights under the law, not to be denied or abridged on account of sex, the amendment also very importantly empowers Congress to enforce. Right, so it legitimizes congressional action to take proactive measures, in fact, to ensure that equal rights are not abridged on account of sex. And then there was another provision. There's a provision that almost nobody pays attention to, but Section 3 of the ERA delays the effective date of the amendment for 2 years. And Martha Griffiths and Patsy Mink talked about the importance of that period for both Congress and state legislatures, because what they envisioned was before judges started enforcing the amendment, they thought that that would be the 2-year delay would be the time that state legislatures would really start looking at what laws they had on the books to determine whether they should be not only struck down, but rewritten. Because what legislatures can do that judges can't do quite so well is rewrite laws and to really be attuned to the disparate effects that their laws might have on different classes of people, and to make them better, to draft them better, and to actually design policy. Judges generally, sometimes they do it reluctantly, but as a general matter, we don't think of that as something that judges should do or are particularly good at. And so that 2-year delay in Section 3 was something that some of these legislators in the 70s talked about as an opportunity and an obligation for the legislator at the state and federal level to really create a policy agenda around equal rights.
I actually think I'm really appreciating how you're articulating this tonight, because it really makes me think about the very distinctive way that these legislators were constitution makers in this moment, what they thought we should be doing with our Constitution and how action should proceed forward in the name of the Constitution. And initially they were successful, right? Finally, the amendment is passed out of Congress. It's passed at this moment, as I recall, it seems unstoppable. Am I remembering right, Julie, that they have Hawaii legislature on the phone, on the end of the phone, and that they ratified the Equal Rights Amendment in Hawaii on the same day? Was it Hawaii? They did that. It's like 5 states ratify it within the first week or two.
Yeah. Well, some states were so excited about it that they wanted to be first. And Hawaii was one of them. And I do think that with Hawaii, they might have jumped the gun. They might have just gone, like they knew that the Senate was taking their vote. You know, they'd been talking about it for a while. And so, and I think they might have just gone technically a little bit too early. So they had to have another vote.
So, you know, at the moment that the states start ratifying the Equal Rights Amendment in 1972, it seemed pretty unstoppable. And there was this broad swell of enthusiasm and support for the amendment. But that was a bit misleading, because within months or even just before it finally moves on for the ratification process, conservative opponents begin to organize and rally, led by the very well-known conservative activist Phyllis Schlafly, who founds the group Stop ERA. And one of the fundamental arguments that Schlafly and other opponents make was that the amendment would be particularly bad for mothers, which seems to me the very opposite of what these legislators were saying, these ERA mothers were saying. So why did Schlafly think the ERA would be bad for mothers? What was the basis of that argument?
Well, one thing that I want to set the record straight on is that Phyllis Schlafly did not invent the argument that the ERA would be bad for mothers. And although she created a nice logo that says Stop ERA was going on before Congress even adopted it. She just wasn't involved with it. So there were very strong male opponents in Congress who started talking about motherhood and started talking about it in 1970, when the House took its first overwhelming vote in favor of the ERA. And in fact, the Senate stops the ERA in 1970. Even though the House voted by an overwhelming over 90% majority to adopt the ERA, it stalled in the Senate. And it stalled even though there was a lot of support in the Senate because a few powerful opponents kept droning on and on. And what they kept talking about was the fact that the ERA would destroy American motherhood. They did say that before Phyllis Schlafly came on the scene. Some gems of lines that you get from Senator Sam Ervin, who was one of the chief opponents of the ERA in the Senate, conservative, who had actually been part of the filibuster of the 1964 Civil Rights Act. So Sam Ervin says God couldn't be everywhere, so he invented mothers, and this amendment is going to destroy American motherhood, right? So he says an ounce of mother is worth a pound of priest. So this idea gets planted in the opposition to the ERA, and it's in the opposition to the ERA even before Phyllis Schlafly comes on the scene that Sam Ervin, he's the one who really insists on there being a 7-year deadline on ratification of the ERA. The original version that garnered over 90% of the vote in the House did not have a deadline, but it stalls in the Senate, partly over the deadline issue, but much more substantively on these issues related to motherhood. So, but of course, when Phyllis Schlafly enters the scene, and it's kind of strange how she enters the scene, because actually in 1970, while this whole conflict that I'm describing within Congress is going on about the ERA and motherhood, Phyllis Schlafly was actually running for a seat in Congress in 1970, never mentions the ERA in her campaign, and she admits later on that she didn't even think about it at the time. And she loses to a Democrat who votes for the ERA on the one hand, George Shipley, but on the other hand goes around saying, don't vote for Phyllis Schlafly, she should really stay home with her 6 children and her husband, you know, instead of criticizing my foreign aid votes and talking about international relations. And so I think Phyllis Schlafly really sees a political opportunity her star really rises with her opposition to the ERA. And I think the new Hulu TV show really depicts that very nicely. In any case, she argued, and this was consistent with what Sam Ervin had been arguing in the Senate, that the ERA would actually wipe out every possible sex distinction in the law. So she made it seem as though if there was any presumption in favor of mothers in custody or divorce, and very importantly, in the context of the Vietnam War, when the draft was extremely unpopular anyway, she argued that women would have to be drafted. And if you drafted mothers, this would also destroy the American family. And so she made a lot of arguments based on one particular extremely rigid understanding of what the amendment would do, which was not shared by the proponents. The proponents, that they had complicated views about what should happen to the draft. Some of the proponents that I mentioned, like Patsy Mink and Shirley Chisholm, actually wanted the draft to end, period. And in fact, they thought the ERA would help in that prospect, because if everyone had to be drafted, both men and women, that might lead political leaders to end the draft. And even without the ERA, the draft did actually end. In 1973, we've had an all volunteer military since 1973. And also many of the proponents also believed that in some circumstances, sex distinctions could be tolerated. But the whole point of the ERA was that judges and legislators should be really careful about treating men and women differently, to make sure that it was actually based on equality. Any kind of different treatment should be in the service of equality rather than in the service of perpetuating women's second-class citizenship or perpetuating gender stereotypes that kept women subordinate in American society up until that point.
So as the opposition movement rallies over the course of the 1970s, that clause you mentioned earlier about the kind of 7 years for ratification of the Equal Rights Amendment becomes increasingly important. And it's a unique dimension of the ERA. And I'm wondering if you can explain that clause and how it set the ERA apart, because I think it sort of sets the stage for where we end up today.
Yeah, absolutely. So the deadline is interesting because on the one hand, it doesn't set the ERA apart from other amendments in the 20th century. That is, since Prohibition, this notion that Congress is going to put a deadline on ratification, typically 7 years, becomes a normal part of constitutional amendment making since Prohibition. But the way in which Prohibition was different was that when the Prohibition Amendment was proposed, that 7-year deadline was written into the amendment itself. It was part of the thing that became part of the Constitution. Whereas with later amendments, including the 24th, 25th, 26th amendments, in these amendments, it was the deadline was put into the proposing clause of the amendment. So Congress, it wasn't part of the thing that got added to the Constitution, but Congress said in preliminary language introducing the amendment that it would be valid when ratified within 7 years. But that said, what's also different about the ERA, although what the ERA's deadline is a formulation that was also used with the 25th and 26th amendments. And that formulation just says that the amendment will be valid when ratified within 7 years. Now, earlier language in deadlines, whether it was the Prohibition Amendment or the 23rd and 24th Amendments, had much more conditional and stronger language. So in the Prohibition Amendment, it says that the amendment is going to be inoperative unless ratified within 7 years. And then the 23rd and 24th Amendments, even though those 7-year deadlines are put into the preliminary preambles and not into the text of the amendment, they speak a much stronger language. They say that the amendment would be valid only if ratified within 7 years. But the 25th Amendment, the 26th Amendment, and the ERA all say valid when ratified within 7 years. So going from inoperative unless, only if, to when ratified, I think leaves ambiguous what the significance of that deadline is and whether or not it's really a very hard deadline. And that's what the controversy now is about, because the deadline passed, the deadline was 1979, and Congress actually extended the deadline once, but even the extended deadline was 1982. They only extended it by three additional years, and no additional states ratified by that time. But the fact that they extended once, that really hadn't been done ever before, but it really does set this historical precedent and a theory of Congress's power over the amendment process, which suggests that Congress has the power both to impose these deadlines and to change them. And so there's this possibility now that Congress can remove the deadline altogether pursuant to its power over deadlines.
Yeah, and that's definitely sort of part of some of the exciting developments that have been happening in recent years. So as of January 1st, 1983, like the historical records I read is like, this is just a day of tragedy for feminists. And really for 30 years, it seemed to me that the Equal Rights Amendment was kind of off the table. But within the last 5 years, there's been some new developments, a new generation of ERA mothers advocating for it. Can you tell us a little bit about some of these exciting developments over the last couple of years?
Sure, and that's one of those developments are why I wrote this book, and a good chunk of the book is devoted to telling the ratification stories that just took place since 2017. Because you're absolutely right, people just kind of presumed the ERA expired and dead for quite a while, but in 2017, Nevada actually ratified it. And of course, as of the deadline, 35 states had ratified it, but that's 3 states short of the 38 you need under Article 5 to make 3/4 of the states. So we were 3 states short then, but we got 3 ratifications in the last 3 years. And so Nevada in 2017, Illinois in 2018, and Virginia just earlier this year in 2020. And there are a lot of explanations for why this is happening. I don't think it comes out of nowhere. So another story in our Constitution that's quite bizarre is the 27th Amendment, which actually got added to the Constitution. And the 27th is the last time our Constitution was amended, and it got added to the Constitution in 1992. Now, that's an amendment that actually James Madison wrote way back in 1789. It got sent to the states for ratification with the original Bill of Rights, but not enough states were excited about the 27th Amendment. The 27th Amendment just says that Congress can't give itself a raise, or if it does, it doesn't go into effect until there's been an election. Okay, so that's what but what's really super interesting is that the moment that you described, 1983, when the ERA deadline expires, this kid in Texas says, well, if an amendment has no deadline, does that mean that it's still viable? So he digs up this amendment, the Madison Amendment as it's known, and only a handful of states had ratified it in the 19th century. And he says, it seems to make sense. Why should Congress be able to give itself a raise and let it go into effect immediately. It seemed like a great anti-corruption provision. So he starts writing to state legislatures. But I tell the story because even though it's not really about the ERA, it absolutely is about the ERA. People are thinking about what is the effect of deadlines, and this kid is thinking about what is the effect of deadlines when he writes a paper, gets a C on the paper, but then starts this letter writing campaign to legislatures. So I want to suggest that it's actually the ERA's weird and winding history that's in part responsible for the 27th Amendment. So the 27th Amendment finally gets ratified by 38 states by 1992 and gets added to the Constitution somewhat uncontroversially. And it's only because the 27th Amendment gets added that then ERA activists building on that say, well, if the age of an amendment doesn't preclude it from being added, then maybe it's possible to continue to ratify the ERA and have Congress do something about the deadline, right? The ERA is different from the 27th Amendment because the 27th Amendment didn't have a deadline. Deadlines were not part of the practice in the 18th century when the 27th Amendment was first introduced. But it's because of the 27th Amendment that I think you see some rumblings in the 1990s about what's known as the three-state strategy. Is it possible to have 3 additional states post-deadline ratify it and to have that be legitimized in some way? And I would say, though, that and in some of these state legislatures like Nevada, Illinois, and Virginia, there are efforts throughout the from about 2000 to onward occasionally to introduce ERA ratification resolutions. But I would say that the steam really picks up with the Women's March. And I think because of the 2016 presidential campaign, drawing a lot of attention to misogyny as a public problem, and perhaps to the importance of women in politics after 2016 and the Women's March. I think that really creates a lot of momentum for the ERA in Nevada, certainly, led by Pat Spearman, a woman of color in the Nevada Senate, who is also, she was in the military, and she is also a member of the LGBT community and an ordained minister. So she actually introduces the resolution in Nevada, and it's successful. And then I would say in 2018, there are a lot of women in the Illinois legislature who are working on a lot of issues. This is very Patsy Mink. At the same time that they're introducing the ERA ratification resolution, they're really creating a task force and proposing new legislation to respond better to sexual harassment and violence against women because of the Me Too movement. Right in the thick of 2018, allegations against Harvey Weinstein, stories about sexual harassment in the Illinois legislature itself emerging at that moment. And then finally in Virginia, it was something that actually there were women of color in the legislature who had been trying to have the ERA ratified for several years actually before it's finally successful in 2020. Arguably, if you look historically at what happened in Virginia, they never stopped thinking about it. There were all these efforts in the 70s and a movement in the 70s that failed largely because of the way in which the powerful committees in the Virginia legislature really stopped the ERA from getting a fair debate or a floor vote. And I think there's in Virginia a real sense of unfinished business and unfair procedures that stopped it for all those decades. And so in Virginia, the story is very much about getting the state to the right side of history, finally. And they do that by taking their ratification votes led by women of color in the legislatures earlier this year.
We're about to shift over to audience Q&A, but I in light of all of this new momentum and the kind of energy around the Equal Rights Amendment that's been building over the last couple of years, I wanted to ask you if audience members were to go home and share with family and friends one argument for why we need to ratify the ERA today, what should that argument be?
So here, I think it's really important. I think that we often talk about the ERA, about what it would change in the law. And I think that that's actually not the most important argument. because one of the things I detail in the book is the way in which, because we didn't get an ERA, women lawyers and lawmakers found a lot of substitutes for the ERA and found ways to address some of the problems that gave rise to the movement for the ERA through other legal means. So I don't think that we need the ERA as a doctrinal fine-tuner of our laws. That said, I still think it's extremely important because it's important that we have founding mothers of the Constitution and that we make it official. We do have founding mothers. Women have been changing the Constitution, whether we get this amendment or not. They have changed what the Equal Protection Clause means. They have adopted many other laws that have constitutional significance in terms of the values for which our Constitution stands. So women have changed the Constitution, but because of the ERA's failure, we think of women who changed the Constitution as failures and losers rather than founding mothers. I mean, I'm exaggerating the contrast a little bit, but I do think that it's very much a question of giving credit and legitimizing something that has been happening. And I think one of the deepest problems of misogyny and gender inequality in American society is not hatred of women, but general forgetting, invisibility, and undervaluing of women's contributions, both to the economy and to democracy. And I think we should need to stop undervaluing women's contributions to constitution making. And I think getting this amendment legitimized is part of that process of valuing women's contributions to democracy and recognizing founding mothers as well as founding fathers.
I think you've just inspired people to some great dinner table debates and conversation. We're starting to get questions coming in. We have a pretty straightforward one to start with. Are there any other amendments that are currently in limbo and awaiting ratification? And I suppose I would add, does that affect thinking about potential ratification of the Equal Rights Amendment?
Well, I think this is actually one of the questions that gives people pause about the Equal Rights Amendment, because there were amendments that were adopted by Congress but were not ratified by the requisite number of states, including what's known as the Corwin Amendment. The Corwin Amendment before the Civil War would have preserved the state's autonomy over matters of slavery. And arguably that amendment would be deeply in conflict with the 13th Amendment if any states wanted to start ratifying it again. Okay, so there's one. Another example is the Child Labor Amendment. And the Child Labor Amendment is a super interesting amendment because that too, earlier in the conversation, we talked about how there were some women who really were in favor of the ERA and some women who kind of opposed the ERA because they were interested in getting real legislation that would make equality real for women, especially women workers and also for children. And some of those women proposed a child labor amendment, which was adopted by Congress, but it didn't get enough ratifications to become an amendment. There were 20-something number of ratifications in the 1920s and 1930s. It's an amendment that's thought to be no longer needed because part of the reason, the whole idea behind the Child Labor Amendment was not to explicitly protect children's rights, but actually to empower Congress to legislate around child labor, to regulate child labor. And the reason the amendment was proposed was that you had a Supreme Court at that time that was striking down legislation at the federal level that attempted to regulate child labor. But once the composition of the Supreme Court changed and the Supreme Court was no longer hostile to labor legislation and particularly child labor legislation, the amendment came to be seen as obsolete. And so that's another example though of an amendment that was adopted but hasn't been ratified. I think there are others. This would also make a great subject for a paper that could lead to tremendous constitutional change as happened at the end of the last century.
Am I right in thinking that from your perspective, the way to go now is to build on the previous ratification campaign rather than to start anew? That would be too much of a setback. What's the reasoning behind that? to stick with the previous kind of process?
No, that's a great and difficult question for me, because arguably, it might be better to start again, because maybe we could even write the language differently to say what we really mean, right? So a lot of people worry about an ERA that was adopted in the 70s, because the idea of sex in the 70s did not encompass what we think of today. Today, I think, as evidenced by the Supreme Court's decision in Bostock just this past term, I think our modern understanding of sex definitely includes discrimination on the basis of sexual orientation and gender identity, right? So that's how, when we talk about sex, we sort of think about it as gender rather than biological sex. So we have notions of what that means today that's different from the 70s. And also some people say if we're going to have an amendment, maybe we should write it more carefully to make sure that it includes things more robust than what the original proponents wanted in the 70s, right? And I think there's a certain appeal to that, but I think the reality on the ground is that Article 5 of the Constitution requires 2/3 of Congress and 3/4 of the states. And I think today we're much more polarized, and I think it's much harder to imagine 2/3 of Congress agreeing to anything in the same session. And it's very hard to imagine 3/4 of the state legislatures ratifying all over again. And when I say that, this has to do with certain dysfunctions in our politics. That is, even if there's overwhelming public support. In fact, right now, there's overwhelming public support for an equal rights amendment, but we're still embroiled in some conflicts about whether it could be legitimized. But I do think that this question is important because I think that thinking about the ERA and its weird trajectory should draw attention to how hard Article 5 makes it to amend the Constitution. That is, what kinds of amendments are permitted by that rule, and what kinds of amendments require generations of buildup under that rule. And specifically, I think with the ERA, one thing I've learned in writing this book, though, is important through lines and building that has happened transgenerationally. So I think there's also some benefits to a transgenerational amendment where what was needed or proposed in the 70s had to do with women's disadvantages because they were mothers. And on the one hand, and then in the 21st century, some of those issues are still being talked about. Some of the ratification debates have even added the concerns about sexual orientation and transgender rights in their ratification debates. So I think there is a way to have a robust transgenerational 21st century amendment emerge from the process that began 50 years ago.
And that gives us a perfect opening to talk about who are the leaders or politicians today who are continuing the legacy of the founding mothers? Who are the members of this next generation? You mentioned Pat Spearman. Are there others we should know about?
Yeah, absolutely. So in Virginia, I mean, the Virginia story is one that's incredibly moving. We have African-American women of all three different generations leading the ratification fight. So Jennifer McClellan, who's been in the legislature for the last about 15 years, an African-American woman. She has been a proponent of the ERA for many years, and she's now running for governor of Virginia. Jennifer Carroll Foy, also in Virginia, more of a Gen Y or millennial. And she, what's really amazing about her story is that she was one of the first women and one of the first African-American women to attend VMI, the Virginia Military Institute, after it was integrated in a Supreme Court decision authored by Justice Ginsburg in 1996, United States versus Virginia. And United States versus Virginia is a real landmark decision that incorporates sex discrimination as a constitutional problem under the Equal Protection Clause. And VMI gets integrated because of that decision. And a woman who goes to VMI because of that decision becomes one of the leaders of the fight for the ERA. And so I think these stories make a huge difference. And then in Congress, you had record numbers of women, including women of color, elected to Congress, to the House, especially in 2018. And some of those women have been very vocal in giving 21st century justifications for ratifying and removing the deadline on the ERA. So those women include Pramila Jayapal and of course, even some of the veterans of Congress, like Nancy Pelosi, gave a speech in favor of lifting the deadline that focused on the fact that pregnant women are discriminated against in the workplace and that there isn't enough support or enough done to reduce inequalities that women face because they're mothers.
We have one last question, which it lets me sneak in one question I didn't get to ask you before. I have a question about, women standing together in terms of supporting the needs of the family, right? And fighting for the rights of the family. And you close We the Women with a call to ratify the ERA for working mothers and mothers to be. So I'm curious, why for mothers in particular? What does that say to you about the vision and the purpose of the Equal Rights Amendment today?
Well, I think it's important for two reasons. One is that I think the standard account of why the ERA failed in the 70s has everything to do with motherhood. And Phyllis Schlafly really drew attention to, she claimed, and she wasn't the only one, many opponents said that this would be bad for mothers. And I think that really erases the fact that from the beginning, like from the 19th century, the movement for women's rights really drew attention to the sources of women's inequality. And those sources were women's role in childbearing and child rearing. That was central to early justifications for why, for example, the Supreme Court says in 1873, a state can deny women a license to practice law, right? So women's role in childbearing and child rearing has been an important part of the justification for excluding women from fully equal citizenship, economic and political citizenship. And in the 1970s, you see the proponents of the ERA really drawing attention to some of the inequalities women face because of their role in childbearing and child rearing. The Women's Strike for Equality in 1970 also squarely addresses those issues by calling for childcare as a necessary condition of women actually having equal opportunity. But despite this, despite the fact that motherhood has been such a central focus as a source of women's inequality, motherhood inequality has actually been left behind by the gender equality law that has been successful over the past 50 years. So even though the Supreme Court recognizes sex discrimination finally in the 1970s as an equal protection problem, it also writes a few decisions saying that pregnancy discrimination is not a constitutional problem, is not sex discrimination, at least under its interpretation of the Equal Protection Clause, right? And I think that politically there isn't, it's been hard to get momentum for things like paid family leave or childcare, or even though we have statutory pregnancy discrimination law, and now more states have come on board with Pregnant Worker Fairness Acts that actually accommodate the needs of pregnant workers at the federal level. There's been some movement, but I think we fall way behind many other constitutional democracies in really addressing motherhood as a source of inequality. And study after study shows that even things that a lot of people seem to care about, like the gender wage gap, if you control for motherhood, the wage gap between women and men is actually a lot smaller than when you compare mothers.
Mm-hmm. So one of the sort of core anchoring ways that gender inequality still plays itself out in our society is through motherhood. And
absolutely. And the reality on the ground is also that 86% of American women become mothers, give birth before the end of their childbearing years. And I think that's something that we don't often think about. So if we're going to have any kind of law or policy agenda on gender equality, to me, it's crazy not to think about the needs of mothers.
Mm-hmm. Yeah, I really appreciate you kind of putting that out there for all of us to think about it, because I think it really shifts our frame of reference for thinking about that an equal rights amendment is just about individual women's rights before the law and equal treatment and equal wages, and puts it in a much broader context and a very different frame, and gives us plenty to chew on, and encourage us to pick up the book, the wonderful We the Women, The Unstoppable Mothers of the Equal Rights Amendment. It's a joy to read. It's indispensable history. I'm going to be assigning it in my classes. I've told my daughter and all her friends to read it. So I encourage all of you out there to pick it up and sit down with it. And learn about the wonderful mothers of the Equal Rights Amendment that Julie Suk shares with us. And thank you all for joining us this evening, and to the New York Public Library for hosting this conversation.
Thank you.
Black text on white background. New York Public Library Lion logo, 125 years. Learn more about the New York Public Library, nypl.org.